Hello, students. This evening, or today, depending on when you're watching this, we are going to talk about tort law. Now, as a practical matter, what is tort law? Well, the easiest way to think about it is, first, let's divide law into criminal law and civil law. So we're talking about civil law. And indeed, that doesn't involve the state. Nobody's getting arrested. It's private individuals, private companies suing each other. Now, you can then largely divide that type of law into either contract law or tort law. So, for example, some time ago, I think I talked about, let's say that you rent a car. You go out, you go drinking, you run into somebody else, okay, and destroy their car and put them in the hospital. Well, then you don't have insurance on your own car, so you can't pay for destroying the rental car. The rental car company will sue you for breach of contract because you broke, if you will, or breached the contract to have insurance on that rental car, which you did not. However, the poor person you hit, he can sue you for tort. That is, here you go, a civil, not criminal wrong. Doesn't have to do with the breach of contract. It's a breach of a legal duty. Now, let's add two more. Approximately causes the person harm or injury. Now, legal duty. That basically says even if you don't have a contract with someone, you still have a legal duty to act reasonably. You had a legal duty not to run over this poor guy or to smash into his car. Now, tort law basically provides people that don't have contract rights a remedy when someone has caused them physical injury, property damage, etc. This is a legal remedy, if you will, or legal right to get recovery against the person that caused that. Okay. Now, when I say damages, you can recover damages. Damages in this context are a legal term of art, and they have to do with what a court recognizes as reparation. Okay. How can you be made whole because of the injury, whether that's property injury or injury to property, and I'm using injury purposely so I don't conflate it and use the same term as damages, injury to property and or injury to person. That money, the quantification of your injury in dollar figures are damages, and that's what you can seek to have recovered. Now, there are many, many torts that we're going to talk about just here in a little while, but you can largely talk about types of damages. There are, let's call it two categories. Category one, compensatory damages. So I'm going to reimburse you. Let's say you ran into me, or I ran into you in the car. Well, I'm going to reimburse you for your actual damages. You had to go to the hospital. You might have a limp for the rest of your life. And, I've ruined your car. Well, those are all damages. They compensate you for your loss. Now, compensatory damages, in turn, can be divided basically into two things, just two types of categories. These are all compensatory damages. Special damages, and that just means, hey, these are very specific dollar amounts I can show a judge and say, I lost this because of that idiot in his car and what he did. Now, there are also a thing called general damages that in some instances, if you've had pain, suffering, mental anguish, etc., disfigurement, that's a good example. I hit you and you have a scar, your face is scarred. Well, you can't go to a judge or to a jury and say, I have this scar on my face. I'm going to have this scar for the rest of my life. And it's hard for you just to say, hey, so that's worth X dollars and here's the invoice to show what it's worth. No, you have to go to a judge or jury and say, this is going to be traumatic for the rest of my life. That's a type of general damage. I can't pull up an invoice and show you what I paid, but still I have a right, you have a right to be compensated for me disfiguring your face. All right, now, damages, category number 2 of damages or remedies, what you can get if you're suing somebody for a tort. I ran into you. A second type of damages are called punitive. And that is where not only have you received your compensatory damages, man, you've been disfigured and you paid for your car and your medical, etc. But what I have done is so egregious that you really have the right to sue me for punitive damages. Now, always think of Latin or Greek when you're looking at English or law, and you'll notice punitive and punishment have the first 3 letters in common. So punitive, a good way to remember that is a punishment, if you will. It's hopefully to deter similar conduct in others. So, for example, if I was working for Amazon, I was a truck driver, and I had been in 30 wrecks and ran over people, but Amazon still hired me. Well, it seems like it would make sense for you to be able to sue me or sue Amazon for using such poor judgment to hire an idiot like me that is likely to run over somebody or hurt somebody while I'm driving, right? And so the concept here is, if you win the judgment, Amazon and myself as a driver are liable for my bad acts, then you're able to put on evidence to the judge or jury, depending on the case, to prove, hey, Amazon should be punished because of hiring this lunatic to drive. Well, if you do that, good heavens, you can look into Amazon's total value. So, a jury might award $20 million to you, for example, if they believe punitive damages are appropriate to send a message to punish Amazon. You shouldn't have done this. And theoretically, the one of the main reasons why punitive damages is to send a message to other companies: do not hire these type of employees for driving positions. So that's why we say it's theoretically supposed to deter similar conduct in the future. Let me give you an example on a news story we'll watch real quick. And there'll be an ad before it, and I apologize for that.
The official personal injury attorney sponsor of the Dallas Cowboys. After a car accident, it can...
There is a major verdict just in tonight involving a couple and a common lawn product that they blame for their cancer. Monsanto has been ordered to pay $2 billion to the couple. And here's ABC's chief national correspondent, Matt Gutman now.
Tonight, that bombshell verdict. A California jury finding that the weed killer Roundup hazardous to humans, likely causing the cancer of Alberta and Alba Pilad, who say they used it on their properties for decades. Roundup is one of the most widely used weed killers in America, in use since the 70s. That jury slapping Monsanto with over $2 billion in punitive damages. It's the biggest in 3 bombshell verdicts in less than a year that have gone against Monsanto and its owner, German chemical giant Bayer AG. The jury trials found that the active ingredient in Roundup, glyphosate, likely caused non-Hodgkin lymphoma. Tonight, Monsanto says that leading health regulators agree that the products can be used safely and that glyphosate is not carcinogenic. David Bayer tonight says it will appeal the verdict. Still, it faces more than 13,000 additional cases. Could be a long legal road ahead for the chemical giant. David.
All right, Matt.
Okay, so basically you see, what was it, $2 billion that was awarded to this couple. Well, they didn't have $2 billion in damages, but a judge and or jury assessed that much to punish Monsanto and to say, hey, you not only should you not sold this, don't sell it in the future. So that's sort of the public policy behind that. Again, compensatory damages, punitive damages. All right, we're going to keep going through. Now, let's talk about classification of torts. We've already talked about the damages that you might recover if someone commits a tort on you. Well, what kind of torts are there? What do you call them? Because when you go to court, we have to say or characterize in our pleadings, we call them, in what we file with the court. What are you calling it? I'm not calling it a breach of contract. What do I call it? It might be negligence. It might be something else. So theoretically, you can see that we can divide these various torts into intentional torts and unintentional torts. Now, unintentional torts are basically negligence. I'm driving 55 and in a 40, and I might, get in a wreck. Well, I think I'm pretty negligent in that situation. I wasn't following the duty of care that I have to my fellow drivers on the road. However, if I'm walking down the street and somebody sees me and runs me down because I'm a lawyer, now you might find that to be appropriate, but at least the courts will protect me and say, wait a minute, that's an intentional tort, and that is restricted. Let's give you a couple of videos, and I want you to tell me if you think these were intentional or non-intentional.
Two exes get into a spat while driving.
The man gets out of the truck and the woman does something dramatic while driving down I-4. News Channel 8's Ryan Hughes is live along I-4 for us right now. And Ryan, what happened next?
And good evening to you both. This is the area along I-4 where the man got out and then the woman's accused of running over him. Nighttime on I-4, exes driving east just past the Florida State Fairgrounds involved in a pretty heated argument in a pickup truck.
And the ex-boyfriend decided he was going to get out of the car, and he went to the other side of the interstate.
That's right. The man gets out of the truck on one of the busiest roads in the Bay Area. Then another twist.
She crossed 3 lanes of traffic perpendicularly and then hit him, then took off from the scene.
An eyewitness followed Alicia Belcher.
911, what's your emergency?
911 on I-4, a lady just ran over a guy.
Hillsborough County Sheriff's deputies arrested her a few miles away.
And when they took her into custody, they immediately noticed that she was under the influence. They gave her some field sobriety tests. She also gave breath samples to our deputies, and she was almost 3 times the legal limit.
Okay, I hope, now, ladies, probably you've had this desire to run over an ex at some point in your life. But I also hope we would recognize that indeed that's an intentional tort, that it looks as though after she crossed diagonally 3 lanes of traffic, that the person that committed the tort, the lady driving, intended to run over this guy. Let's watch one more. Well, it looks like that one's not available, so you'll have to trust me that as well was an intentional tort. Now, let's talk about 2 other kinds, intentional versus negligent. While you're working your way through NSU, you work at Target, okay? Well, at night, you don't see anybody around. Somebody happens to be in the dressing room, and you close down, shut off the lights, and close the Target store. Well, heavens, you've essentially imprisoned someone, if you will, within Target for the night, unless they're able to bang the door and get an alarm off or something. But I suspect you didn't intend to do that, so that would be negligent. Conversely, if you kidnap someone, rob them, hold them at gunpoint, well, that's an intentional false imprisonment. So now you see 2 instances in which someone is held against their will, but one would be negligence and one would be an intentional tort. Okay, now I'm suing you. Let's put the legal shoe on the other foot, shall we? If I'm suing you for a tort, claiming that you committed a tort against me, how can you, dear student, defend yourself? Okay, well, that depends on the tort. But if you can prove the elements of one of these defenses. In other words, even if I prove you committed the tort, but you prove you have a defense, then you can actually escape liability. Let's jump down here. We talked about it. I'll let you read through intentional tort. We've talked about that. Let's talk about some intentional torts real quick. Assault. Now, you might hear someone assaulted me. Well, that does not mean they hit you. That would be a battery. But it does mean that that individual, and it's not even just, oh, I hate your jeans are ugly, or spreading a lie about you. That's not assault. Assault is when you have a threat of immediate harmful or offensive contact. So I'm in a bar and I'm being a smart aleck and you tell me, I ought to kick your butt. I would suggest that that's not assault because you have not really threatened me. You've stated, well, I ought to do this. Conversely, if you stand up and raise a fist and you're about to hit me and someone stops you, well, that would be assault. All right. Now, if you follow through and smack me, some might argue that it's well deserved, but if you indeed do hit me, then that would transform to battery. Now, keep in mind, there's a criminal assault, a criminal battery. That's not what we're talking about here in business class. We're talking about I can actually sue you for both, in this instance, assault and battery, because at this point, once you've hit me, you have done both. We talked about false imprisonment. There's an interesting intentional tort that's a little tougher for us to prove, an infliction of emotional distress. And sometimes you are successful in pursuing this tort when it's been just outrageous conduct. Somebody drives carelessly through Mayfest downtown and runs over people. Well, in addition to, now, footnote, you could sue me if I did that for a number of things, for assault, for battery, for, negligence. You could sue me for a number of torts. When you go to court, you're not limited to one tort. You could list a number of them. Well, that's such an egregious act by me that exceeds, as you see, the bounds of decency accepted by society, that you probably would be successful in also suing for infliction of emotional distress. So think about this. I miss you. I don't hit you, so you don't have hospital bills. You don't have car injury, but you've had to go to a therapist for 3 months because of PTSD. Well, you don't have any damages under assault. You don't have any damages under battery because you don't have an invoice you can show. Hey, here's my physical injury, my damages or my medicals. No, but under intentional tort, infliction of emotional distress, you could say, I literally went to therapy. This is what it cost me. And in those instances, if you were successful, you'd be awarded not only the cost of your therapy, but possibly punitive damages because I have undertaken such an egregious act. Now, let's look if this is still available. If not, I apologize, but these are from last semester as well. But let's talk about are these interactions intentional infliction of emotional distress?
Welcome to Contemporary American History. I'm Professor Turgeson. A lot of people think history is just facts. It's just information about the past, but not me. I hold history very sacred. Sacred. The way the farmer looks at the earth and he holds it sacred. The way a Christian takes the Bible and he holds it sacred. The way a lot of people hold their marriage sacred. That's how I feel about it. So why don't we dive right in by interpreting one of the easiest events in the last 20 years of American history. Now, can someone tell me why in 1975 we pulled our troops out of Vietnam?
The failure of Vietnamization to win popular support caused an ongoing erosion of confidence in the various American but illegal Saigon regimes.
Is she right? Because I know that's the popular version of what we're doing there. I know a lot of people like to believe that. I wish I could, but I was there. I wasn't here in the classroom, hoping I was right, thinking about it. I was up to my knees in rice paddies with guns, and then we're going up against Charlie, slugging it out with him, while pussies like you were back here partying, putting headbands on, doing drugs, listening to the goddamn Beatle albums.
Hey, Professor, take it easy, will you? I mean, these kids, they were in grade school at the time. And me, I'm not a fighter. I'm a lover.
Well, I didn't know you wanted to get involved with the discussion, Mr. Helper. But since you want to help, maybe you can help me, okay? You remember that thing we had about 30 years ago called the Korean conflict? Yeah, where we failed to achieve victory. How come we didn't cross the 38th parallel and push those rice eaters back to the Great Wall of China and take the Mercury break and nuke them back into the fucking Stone Age River? How come? Tell me why? Say it! Say it!
All right, I'll say it. Because Truman was too much of a pussy wimp to let MacArthur go in there and blow out those commie bastards.
Good answer. Good answer. I like the way you think. I'm going to be watching you.
All right. I hope you find that to be a humorous example. If this humorous example were taken to court, I might suggest that the professor had intentionally inflicted emotional distress on the first student who commented, but not on the second, because he was engaging in similar deplorable behavior. Okay, let's move on. Defamation. You may have heard of slander. Well, defamation subsumes a couple of different types of lies, slanderous action. So basically, defamation is a tort that means I have wrongfully hurt your good reputation. In other words, the law requires me not to make false statements about you. Now, if I say it to someone else, it's slander. Okay, orally breaching this duty is slander. So remember that. Say slander. If I put it in print, I put it in a paper, I put it in the newspaper, frankly, I download it here on YouTube as a video. Well, that's libel. So I can say the same thing, but those two definitions just mean one is only spoken and the other is recorded in another way. Now, what must you prove to find me liable for defamation? Well, what I said was false. Okay? So, I said you, student, have big ears. All right? Well, if let's say you have big ears, that's not false. Okay? So you fail in suing me. Now let's say you have these beautiful tiny ears or handsome tiny ears, okay? Well, so you've satisfied the first test. What I've said is false. Now, number two, you have to prove what I said would tend to harm your reputation. All right? Now, probably it would be difficult for you to prove that the fact that I said you had big ears harms your reputation, unless maybe you're an earring model. Okay? Then, of course, you'd have to prove it was published. That can mean spoken slander or published in another format, digitally or in writing, libel. Now, if you're a public figure, now that can mean a movie star, an author, a politician is the most example, then you also, if I were any of those, you'd also have to prove, no, let me back up. If you were a public figure and I was saying false things about you, to successfully sue me, you'd also have to prove that I had malice. So every presidential election, every congressional election, oh my gosh, dog catcher election, you hear candidates from both sides of the aisle lying about each other, just openly lying. And if you just get tired of the lying, wouldn't you like to say, just sue his or her pants off, and let's just stop. Let's get back to the facts. Well, if they're public figures, so you would have to prove they had malicious intent. So beware of that. In other words, it's harder to sue for a public figure to sue somebody for defamation. I'll let you read through these. I'm trying to keep this lecture short and let you do reading on your own. Let me point out the defenses. Again, we've already talked about truth. And please read through this, that there are some things that under law that are protected speech. You might say them, but they still can't sue you for it. Absolute privilege. For example, in judicial proceedings, believe it or not, lawyers, again, doing CYAs are protecting themselves. If you say something that's false about the other side, then you still can't be sued for it. If you're saying it only during the judicial proceedings, a lawsuit. Legislators during legislative debates, political broadcasts. How about that? So politicians, right in the law, have made it okay to lie about each other. Okay? Qualified privilege. I'll let you look through that. We talked about defense that you don't have malice. Now, let's talk about another type of tort, invasion of privacy. So I'm looking into, if I'm, coming on your property and looking in your windows, I'm probably, and then tell everyone about what I saw, I'm probably not only trespassed, a different tort, on your property, but I've also invaded your privacy. You'll see this example of a suburban school district that actually thought it would be good to have sort of a spyware in laptops that they gave to the students to take home. Well, that was intentional. It was an invasion of privacy. The students didn't know about it, the parents didn't know about it, so that was a serious problem, and they were guilty of invasion of privacy, and they had to pay a significant amount to settle that. You'll see the other things. You intrude into the affairs, you publish information that puts a person in a false light, or public disclosure of private facts, or appropriation of someone else's names. For example, name, likeness, etc. So, for example, every time you go to Blue Dome Festival, for example, every year in Tulsa, you see guys selling T-shirts that have Brad Pitt's face or some guy's face. Well, they didn't get their right to use that, likeness, and Brad Pitt's not getting $1 for every T-shirt sold. So among the other torts that Brad Pitt could sue, if he wanted to, sue this guy at Blue Dome, he happened to be walking by as he was filming here in Tulsa. Well, theoretically, one could argue, well, there's an invasion of privacy, the use of my likeness without my consent. Okay, more intentional torts. Fraud, right? Intentional deceit. I'll let you see. Do you see these steps down here? Footnote here. Whenever you go to court and you're trying to prove something, whether it's a breach of contract or a tort, you have to prove elements. You can't just say, hey, he misrepresented this. It was fraudulent. No, you have to prove these. These are called elements of that tort. So since you're suing me, you'd have to come prove each of these to the court. All right. I misrepresented something. For example, I sell you my house. I don't tell you, oh, by the way, it's on a sinkhole, and I knew that. It's about to fall into the earth. Well, if it does fall and you come home and your house is gone one day you bought from me, obviously that would be a fraudulent misrepresentation by me. And I had done it to get your money for personal gain. I'll let you look through these. Wrongful interference. That's getting a little far in the weeds for this class, but basically I work, okay, let's set up this scenario. You work for somebody that sells cosmetics, okay? And I work for a competing brand company that sells cosmetics. Well, if I went to your big retail customers, to Walmart or Target, and said, you know, I understand, you know, there's animal testing with my competitor. They do lab testing, or they're harmful, and maybe they're really not. Well, I would be interfering with your contract between you, the makeup supplier, and Target. And that's actually a tort. I'm wrongfully interfering with your contract with your customer. That's a tort. Similar when you get it, and these will all be online, so you can go through these PowerPoint overviews. This is a next two screens are basically reiteration of types of intentional torts. Now the first was against persons, this is against property. We talked about trespass. But these are, again, intentional torts. Now, we've divided all the torts into intentional and unintentional. They're generally just called negligence. So I didn't mean to hurt you, but man, I was speeding. And because I was speeding, I slid on the rein and ran into you. That's not intent. And you don't have to prove that I had intent to hurt you. You just have to prove, look, the speed limit was 40, he was going 55, and it was raining torrentially. Professor Kevin was negligent because he had a duty not to speed, and the speeding resulted in him crashing into my car. Now, what do you have to prove against me? Well, you have to prove 4 things to be successful at court. Number 1, I had a duty. Well, obviously, I owed you a duty of care to not drive like an idiot, you know, on the road. I breached it. Yes, I was driving too fast for the conditions. Third, I caused the damage, okay? So, for example, let's say your car is so jacked up, you're a college student and you're driving a car that's barely held together by duct tape and rust. Well, if I dinged one door, you can't say, hey, that car accident caused all the damage. In other words, you couldn't recover for a whole new car when I just dinged one door. You'd have to prove this causation or causal link between what I had done, hit you, and the resulting damage. Then finally you would prove the amount of damages. That is, in this instance, how much it would cost you to repair that door. All right, so let's go into these individual elements because negligence is big. You know, many of the torts that actually end up in court are negligence. First element, again, these are the elements you'd have to prove that I had a duty of care. Well, who has a duty of care? What duty of care? I think you shouldn't offend my sensibilities. Don't criticize my Facebook post or, you know, whatever. Sorry, that's an old professor's social media platform, but the court is not just going to accept anybody's complaint. It has to be reasonable. How would a reasonable person act? Okay? How should they act in this situation? What is the appropriate degree of care? Okay? For example, side of the road, I stop to help somebody who's been in an accident. I won't be held to the same duty of care that a surgeon might. You know, I do my best Boy Scout first aid. It'd be tough for him to later sue me. But if a surgeon stopped at the side of the road and he happened to be high on cocaine and whatever else and just completely messed it up, the surgeon, would be held to a higher degree, he or she, degree of care than would I. All right, this talks about different kinds of duties. And so before we get on to the second element of negligence, I want to do a couple of notes in here. Number one, I can't put up if I'm a farmer and I have this big farm and I could put up a sign and say trespassers will be shot. Well, yeah, I can say that, but if I do it, I'm sure as hell negligent or probably more likely an intentional tort. Let's say I have a bear trap and if you step on my property gets you. Well, I've certainly been negligent in doing that. So I have a duty of care no matter what I say. Business owners, if you're in a grocery store, they got to clean up spills as soon as they see it. They can't have hazardous stairs or, you go to Six Flags. Well, they can't have, even though you buy a ticket and it says, hey, you're assuming all these risks by riding our rides, they still have a duty of care to make sure the ride is safe for the average person, okay? Negligence element number 3, causation. We're getting really deep in the weeds as far as legal concepts, causation. So I caused the harm to you. When you're suing me, you have to prove that I caused the harm. And you remember we talked about your car was so janky, if you will, that I can be liable for the dent that I caused, but not for repairing or replacing your whole car. But what about an incident where I did something with negligence, but it's not reasonable that I could ever foresee what happened down the road? All right, let's watch a YouTube, and this is a famous old case called the Palsgraf case. And I want you to focus on this concept of foreseeability. Yes, we can sue people that are negligent if they're the proximate cause of the damage, but there has to be some kind of rule of reason. Was it reasonably foreseeable that the damage you're complaining of would have resulted from my bad act? So let's try this one.
In Palsgraf versus Long Island Railroad, Mrs. Palsgraf was standing on a train platform when a man carrying a package rushed aboard a moving train owned by the Long Island Railroad. 2 train employees pushed and pulled the man onto the train, causing the package, which was filled with fireworks, to fall onto the tracks. The rear wheels of the train ran over the package, causing it to explode. The explosion caused a scale on the platform to fall onto and injure Mrs. Palsgraf. Mrs. Palsgraf sued the Long Island Railroad, arguing that had it not been for the railroad employees pushing the man with the package would have never fallen and exploded, and the scale would have never fallen onto her. Palsgraf wins at the trial and appellate levels, and the railroad appeals to New York's highest court, the Court of Appeals of New York. Justice Cardozo, who would later become a U.S. Supreme Court justice, writes for the majority and holds that the railroad is not liable for Palsgraf's injuries because her injuries were not a reasonably foreseeable consequence of the railroad's negligence. This idea that a duty of care is only owed to reasonably foreseeable plaintiffs has since come to be known as the zone of danger test. Here, the package didn't appear to be dangerous, so it wasn't reasonably foreseeable by the railroad employees that their actions would lead to Palsgraf's injuries. Justice Andrews, writing for the dissent, says that a duty to one is a duty to all, meaning that if the injury can be traced to the wrongful act with no intervening events, then this is sufficient to establish liability. Palsgraf would not have been injured but for the railroad employee negligently pushing the passenger, causing him to drop the package. The Palsgraf case is a landmark case in tort law. It helped establish the idea of proximate cause as a limit on the scope of tort liability. Proximate cause means that you can only hold a defendant liable for harm that is a reasonably foreseeable result of the defendant's wrongful act. If you found this video helpful, you can explore all of our content by visiting.
Okay, so you saw that, and I have it on subtitles in case the sound doesn't come through, so I hope that works for you. But in any event, now you see that under the causation element, there has to be reasonable limitations on that, the foreseeability concept. Right, damages, I think that's relatively, we talked about type of damage, but that's a, it's legally recognizable. And we talked about, you could have damages that are based on your car's hurt. You have medical damages, in some instances punitive. Those are legally recognizable, okay? Now, what are some of your defenses? Let's say you get sued for negligence, okay? Hey, you did something wrong. Well, one of the defenses is the Good Samaritan statute. Many states, including Oklahoma, have a statute that says, for example, hey, you see somebody in a car wreck, you stop at the side of the road and try to help them. Well, you're kind of negligent, but you still did your best, that you can't be sued, so you're protected. That's known as a Good Samaritan statute. Here's some other defenses to negligence. You assumed the risk. You knew a risk and voluntarily engaged in it. I mean, for example, let's say your brother goes skydiving. The skydiving company packs his chute properly, but once he jumps out of the plane, unfortunately, he freezes out of fear, and he never pulls the chute. We all know what the consequences are. Well, if you try to sue the company either that made the parachute or the company that took him skydiving, their argument would be, wait a minute, he assumed the risk. He knew what he was doing. He knew what he had to do, etc. So let's look at a couple of videos, and you tell me, I mean, you don't have to report this. It's just a mental exercise for you. In these instances, did people assume the risk?
I'm so glad you're okay, Sergeant Houston. This is Sam with USAA. Do you see the tow truck?
Yeah, thank.
Kinsler picked that ball? Yeah, I'm impressed, Ian. One-handed, Joe Cool.
Barehanded. Sir Machado. Ooh, foul.
Oh my goodness, almost. Wow. I mean, that's really hard to do to hit a line drive.
Okay, well, I'll let you look at the other YouTube videos, but essentially, I would argue if somebody got hurt in a dugout of a pro baseball game that's a player, they probably assumed the risk, okay? Now, a tougher question is if you're sitting watching the game and a foul ball hits you and hurts you, injures you significantly, did you assume that risk? Well, there have been cases where in Major League Baseball, for example, that Major League Baseball didn't bother to put up foul ball nets to protect people, and they sued them. And in some states, in some courts, the Major League Ballpark or the Major League Baseball Club was able to win by saying they assumed the risk. They know foul balls come there. In other instances, they said, no, it's not assumption of risk. You, the Major League Baseball team, could have spent the extra $100,000 and put up a net and would have not have hurt this person. So that assumption of risk is what you need to know. Is that's a defense to negligence. Sometimes it works, sometimes it doesn't as a defense. Superseding cause. Hey, let's look back at that Palsgraf case where the lady had the scales fall on her at the train station. Well, there was a superseding cause. It was unforeseeable. So the train railroad company can say, hey, there was another cause. It wasn't really our fault. We didn't know the guy had fireworks. It was unforeseeable. So there was a superseding cause that caused this woman to be injured. Contributory negligence. All right, I'm going 55 and the 40, but you're walking across someplace with no crosswalk. You're drunk and go walking across at midnight on a road. Well, you sue me for hitting you and putting you in the hospital. I would have to argue I might be partially at fault, maybe 90%, maybe 10%. But you, by being drunk and walking in black clothes in the middle of the night, not in a crosswalk, you are contributorily negligent. And so I shouldn't be 100% liable for your damages. Comparative negligence is that concept. If you are, how do we apportion how much I should pay and how much you should pay if you're walking in the middle of the road, but I was still speeding? If it's still on, let's watch a quick video on this.
A lot of guys that are watching are in school. I highly recommend that you guys try Grammarly. Grammarly is...
In this video, we will discuss comparative negligence. The rule in comparative negligence is that a plaintiff's damages in a negligence lawsuit will be reduced or even eliminated based on the percentage of his own carelessness. Let's say Perry is being careless by playing a video game as he crosses a street. Here comes David, who is going too fast on his skateboard while listening to music. And David slams into Perry. Perry has $100,000 in damages and sues David. And let's say the jury decides that David is 60% responsible for the accident. And Perry is 40% responsible for the accident. The jury decides that Perry was also careless. Perry's own carelessness contributed to the accident. And the traditional rule of contributory negligence would be that Perry gets nothing. But the traditional rule of contributory negligence is no longer the law in most states. Most states apply comparative negligence, where we compare the defendant's degree of fault against the plaintiff's degree of fault. Perry's degree of fault was 40%, so his damages are reduced from $100,000 to $60,000. Many states modify their rules of comparative negligence. For example, in some states, if the plaintiff is 50% or more responsible for his own injuries, then he cannot recover damages in a negligence lawsuit. If you'd like to discuss comparative negligence or...
Okay, so now you see the transition from contributory negligence, which generally is the old rule, to comparative negligence, which is considered fairness before the law. Yeah, let's apportion the damages based on fault or relative fault. This is a reiteration of the video, so I'll let you read that on your own and that. All right, we're going to go very quickly now. I've kept you for quite some time. Let's go through strict liability and product liability. These basically, in negligence, you have a number of things to prove. You know, they were negligent. Well, when it comes to me engaging in a hazardous activity, let's say that I'm blasting in a neighborhood to dig a pool instead of using a backhoe, or let's say that I put a product on the market, company you work for. Well, people, consumers, or nearby neighbors could sue claiming that you, since you were engaged, you put a product in the market, would have product liability, or you're engaged in this hazard activity, you'd have strict liability. So let's look at strict liability first. Again, you're digging a pool in my backyard, and instead of using a backhoe, you use dynamite. Well, even if you covered it and did everything that you thought was careful, if you're using this abnormally dangerous activity and chunk of concrete flies over or a rock flies over and hits my neighbor, you probably have strict liability even if you're not negligent. Okay, did you get that? You are, think about it this way, you are strictly liable. My neighbor doesn't have to prove negligence, or in other words, fault. Strict liability. Here you can see these are the elements. All right. Keeping wild animals is another good example. You know, there was a lady that had a chimp that, boy, I won't even get into the gruesome injuries that it caused to her friend, but if either you keep a wild animal, people that keep tigers, for example, or maybe the 2-bite rule, you know your dog is bites someone, well, then you could be strictly liable if it bites the second person, and you know. Now let's talk about product liability. You don't have to, let's say that you are now working for the manufacturer of a product that I buy. I go to Target, I buy your product. Well, you are very likely to be liable if I am harmed by your product. And the theory is you as the manufacturer have more money, you have access to insurance, risk should be spread to you. I don't necessarily agree with that, but that's the theory behind strict liability applying to product liability. Product liability, it's very easy. That's your liability to your consumers, your customer, whoever uses it, bystanders, etc. You may be liable for them for damages, physical injury, or property damage that your goods cause. Now, you can also be sued. Again, keep in mind, all right, you're working at Toyota USA, okay? You are a manager and you manufacture a car that has faulty brakes, and I severely injure myself when they malfunction. Well, I could sue you for 2 torts, remember? 2 torts. Not just one, but multiple. Well, my first theory is strict product liability, because you should be strictly liable, but I could also sue you for product liability based on your negligence. You negligently didn't ensure that the brakes were correctly sourced and correctly installed and correctly designed. So I could sue you for negligence under product liability. Again, here we go again. These are the things you'd have to show. It's just negligence again. However, if I sued you for strict product liability, when I'm talking about that and for the court, I could find you liable, Toyota of America, regardless of your intent or even if you exercised reasonable care. You read that? Yeah. Even if you're not negligent, you might be found liable. That's known as strict product liability. Here's the public policy. This is why we have strict liability. As representing companies for 30 years, I'm, wearing the management hat, and I see consumers that just use products in such crazy ways and then try to sue companies. So when I'm speaking, I'm very biased, if you will, towards the companies. But this is what you must prove when you're suing my company, right? When I sold it, it was defective. Now, by defective, it could be defectively designed or defectively manufactured. I sell that stuff, and it was unreasonably dangerous. The Toyota brakes did not work. Also, just like other torts, you have to prove, there was harm. The bad brakes were the proximate cause of my injury. And the goods are in substantially the same condition as when sold. What I mean by that? I didn't modify those brakes. So if my Toyota was 5 years old and I took it down to Firestone to have the new brakes put on and they malfunctioned. Well, item number 6, element number 6 under strict liability says, I can't sue Toyota for the bad brakes that Firestone put on because the car is not in substantially the same condition as when it was sold. I would have to sue Firestone. Let's look at this video real quickly.
Every day, I die over and over again.
Imagine that you buy the latest gadget online, like the new hoverboard motorized skateboard. 10 minutes into trying it out, its battery seems to fail and your hoverboard stops suddenly. You fall forward and break your arm. If you were very hurt, would you be able to sue the hoverboard manufacturer or the company who sold it to you? How do you establish who is to blame? Liability describes the state of being legally responsible for something, especially when it causes harm. Product liability is the area of law in which consumers can bring claims against manufacturers and sellers for products that injure people. Product liability makes up a large portion of the cases that end up in court. When you get hurt by a product you bought, 2 conditions need to be met to establish whether the seller or manufacturer is liable for your injury. First, whoever made or sold you the product must do it as a business. The seller can't be someone making things from home or as a hobby. Second, the expectation is that the product has not been changed before reaching you, the consumer. A company's responsibility for making sure its products are safe is different from an individual's responsibility to behave safely. If you're suing an individual, you need to prove in court that the defendant wasn't being careful enough to keep people safe. Product liability is different. Product liability is a form of strict liability, which means that there is no need to prove whether the manufacturer was being careful. The manufacturer is liable anytime it is shown that their product is defective. To sue for product liability, you only need to show one of 3 things to hold the manufacturer liable. You need to show that either they built the product badly, a manufacturing defect, they designed the product badly, a design defect, or they didn't warn you about a risk or danger associated with the product, a failure to warn. Let's look more closely at these 3 reasons for product liability. The first reason for liability is a manufacturing defect. If a particular product you bought was different from all the others in a way that makes it dangerous, it has a manufacturing defect. Let's say you buy a hoverboard, but the one you bought, unlike all the others, does not have its wheel attached correctly and the wheels fly off as you're using it. You can hold them liable for your injuries because the manufacturing defect can be shown. The second reason for liability is a design defect. When a product is not safe as it should have been. Design defects exist before the product is even manufactured. A flaw in the design makes it unsafe to use. Imagine if the wheel fell off your hoverboard because they only used rubber bands instead of bolts. The product was built correctly, but the correct design wasn't safe. This manufacturer would be liable for a design defect. In these design defect cases, the court often compares competing manufacturers' versions of a product, because that's how they see if a flawed design could have been improved in a cost-effective way. Some kinds of danger cannot be designed out of a product. Swimming pools will always create a drowning risk, and combustion engines will always produce toxic exhaust. The third form of product liability arises when there is potential danger involved with using a product and the customer wasn't warned about how to avoid harm. We call this third defect a failure to warn. If you are making or selling a product like this, you can be sued for failing to warn people about the risk of danger. Imagine you're riding your hoverboard doing cool tricks. Of course you will be wearing a helmet. If you look inside that helmet, it'll let you know what kinds of activities that the helmet is not able to protect you from. This warning exists because it's not clear how strong the helmet is just by looking at it. And if you use a bicycle helmet for football practice, motorcycling, or skydiving, you'll be unprotected. If a product doesn't provide the user with enough information to know the risks of their product and how to avoid those risks, the manufacturer can be liable for the warning defect in their product. Manufacturers and sellers are not always liable for injury caused by their products. If you use a product in an unforeseeable way, like trying to use your car as a pontoon boat, they can't be held liable for injuries that result. If you were to modify a product after you buy it, like replacing the tires on your car with skis, same thing goes. Another important thing to keep in mind is that product liability is about injury that results from physical products. There is no liability that results when your video game freezes and you lose your high score. Understanding the principles of product liability gives us the tools to disentangle more complex liability questions presented by emerging technology. Let's consider product liability with respect to driverless cars.
All right, I think that portion of the video is excellent because it tells us what I like is not only the tests or the elements you have to prove, but also the 3 types of product liability. I didn't design it correctly, I didn't manufacture it correctly, or I didn't warn you about a potential defect or potential danger. Right, you see that? We just talked about that. Product misuse. The video, I think, did a good job talking about that. We've already talked, but you can see one of the defenses to product liability is comparative negligence. You did this wrongly. You used our knife that we sell to clean your ears. Well, you know, that's comparative negligence. I'll let you read those. Statute of limitations is an important concept for you guys to understand. If you're going to sue someone for something they've done, for a tort or for a contract, a breach of contract, or a broken contract, if you will, for that matter, each state has what's known as statutes of limitation, and that simply means you can only sue me up for X number of years, depending on what cause of action, whether it's a tort, a contract, something else. In some states, for example, if I've hit you with my car, you only have 2 years to sue me. So you better get on it. Don't wait around for 2.5 or 3 years to sue somebody if they damage your car. Because if you wait after 2 years after the accident, it's too bad. Even if the other person's negligent, there's not a darn thing you can do about it. I'm going to let you look at intellectual property rights and the different types, just because of the time constraints here. We've spent approximately an hour. But basically, it's totally unrelated to contract, totally unrelated to tort law. It's just a completely different type of law that's important for you as you deal with branding your products, making sure you don't infringe your competitors' rights. You know, what's a patent, what's a trademark, etc. But keep in mind, intellectual property is something that's derived from the mind, creativity, if you will. So I'll have you look through those on your own. Thanks very much for your attention today on this lecture, and I will see you next time.